So welcome everybody to the HAI Weekly Research Seminar. My name is Patrick Hines. I am Senior Manager of Research Communities here at HAI. Thanks as always for being with us. Today I'm delighted to introduce Dr. David Engstrom. Dr. Engstrom is the LSVF Professor in Law and Co-Director of the Deborah L. Rhodes Center on the Legal Profession, which is the premier academic center working to shape the future of legal services and access to the legal system. Dr. Engstrom is a far-ranging scholar in the design and implementation of litigation and regulatory regimes, and his expertise runs to civil procedure, administrative law, constitutional law, law and technology, and empirical legal studies. We're thrilled to have him here today for this upcoming seminar on AI and access to justice. So just to give you a little overview of what's coming up today. So there's two powerful forces bearing down on the American legal system. One is the mounting concern about access to justice, including the fact that a majority of litigants in American courts are self-represented. And two, the amazing advances in AI, which have brought even higher order legal cognitions within automation sites. So today's talk will review the institutional, technical, and legal barriers to effective and trustworthy AI-based tools that can help close the justice gap, whether in a fast-growing legal tech marketplace or in courts themselves. And on this latter point, Dr. Engstrom will report on a first-of-its-kind collaboration between Stanford Law School and the Los Angeles Superior Court, which is the nation's largest trial court, and that's rethinking the court's digital pathways for serving court users in evictions, debt collections, and family matters. Thank you again for joining us, and please feel free to jump into your presentation. Thanks so much.
Thank you. Hi, everyone. Really excited to be here and to present to you all on AI and access to justice, which I hope I can convince you is actually one of the most compelling, but also underdeveloped and understudied areas of public sector AI. I'm hoping that some of you might even want to get involved with some of the work that I'm going to describe today. All right, so I'm going to organize my talk today around 4 parts, each connected to a broader claim. And here they are. First, I'm going to tell you about what we think of as the access to justice crisis here in the United States, and I'll give you a sense of the scope and the scale of the problem. Next, given the scale and scope of this crisis, I'm going to argue that AI, especially generative AI, has massive access widening potential and, of course, also plenty of peril. Third part. I'll show you that while there are many founders here in Silicon Valley that are working on direct-to-consumer legal tech applications of various kinds, it's my view that something that I call Courthouse AI, so that's court-hosted AI tools, actually are, for a variety of technical, institutional, and political reasons, the most promising way to try to incorporate effective and also trustworthy AI into the American civil justice system. Here's the fourth thing I'll do. I'll present on that collaboration that Patrick just noted that was launched about a year ago now between Stanford and the LA Superior Court, which is the largest trial court in the country, where we are starting to help them think about how to incorporate AI into their operations. All right, so starting on claim number 1, as promised, the access to justice crisis in the United States is wide and it's deep. When most Americans think of law and the legal system, they think of something that looks like this, maybe with a little boost from Hollywood. But the reality is that most of the American legal system, and I truly mean most, and I'll show you in a moment, looks more like this. So here are some really bracing statistics to get us all oriented. The best evidence suggests that in something like 75% of the 20 million civil cases filed in American courts each year, at least one side lacks a lawyer. And if you look more closely at these cases, it's not hard to see that though they tend to be small scale, they're also highly consequential cases. They're mostly, it turns out, debt collection actions, eviction actions, and mortgage foreclosure actions, and then also various types of family law matters. Dig a bit deeper, and we can see some further really important things about these cases. Here's the first important thing. Most of these cases pit what we would call an institutional plaintiff, so a bank, a credit card company, a debt buyer because the consumer debt industry has become securitized, a corporate landlord, or in certain family law cases like child support matters, the government, always with a lawyer, against an individual defendant without a lawyer. That's the first feature. Here's the second. Many or most of these cases end in what's called a default judgment, in which the defendant fails to show up to contest the case. And this can happen, this kind of judgment can enter against a defendant even where the case has a meritorious defense. And so if the defendant had asserted it, the defendant may well have prevailed in the case. No matter, because with that default judgment in hand, whether it's legally warranted or not, the plaintiff can then seize assets from the defendant, can garnish the defendant's wages, or can get a judgment of the court evicting them from their home. How did we get here? Right? How did we get to this point in the American civil justice system where the modal case in the entire American legal system right now is a debt collection action? How did that happen? Start with some macro explanations, and I'll provide three that I think are most salient. The first is that legal aid funding has declined or at least been stagnant in recent years. So you'll see on the screen that's budget data for the primary funder of legal aid organizations around the country, the congressionally created and funded Legal Services Corporation. That's part of the story, but that's not nearly all of it, not even remotely. Second macro cause is income and wealth dynamics in the US, and it's not rising poverty. Poverty rates have stayed relatively stable over time in recent American history. Instead, it's rising precarity. So I think the best data here comes from Yale's Jacob Hacker. He shows that short-term income volatility is 3 times higher for Americans than it was 30 years ago. So on average, Americans have a 17% chance of seeing their family income drop by more than half from one year to the next. And that's more than double the probability of that happening in the 1970s. And the inevitable consequence of this is higher bankruptcy rates and rising numbers of home foreclosures and an inability to make rent. A third macro cause is something I call technology's affordances and asymmetries. And here's where we can start talking about technology and at least begin to talk about the role of AI within the civil justice system. On the left, you can see that that Americans' overall debt load has risen. That's data from one of the Federal Reserve banks. And some of that, of course, just reflects a greater taste for debt, greater availability of consumer credit. Some of it reflects growing precarity. And because of this, we've seen a huge spike in debt collection cases in American courts. But a bigger part of the story here may be AI, because those institutional plaintiffs that I just mentioned, they are increasingly using technology, some of it fairly straightforward robotic process automation, but some of it more sophisticated forms of AI, to pull together the case filings they need to assembly line these cases through the American courts. And what it's made possible is for debt collection entities and banks to bring cases for smaller and smaller amounts of debt because the cost of actually bringing the case has declined. In the meantime, that by the way, is technology's affordances. In the meantime, and for a mix of political and regulatory and economic reasons I'll explain in a moment, all of those individual defendants on the defendant side of the V do not have the same access to technology. And that's the asymmetries part of technology's affordances and asymmetries. All right, those are the macro causes. But once you get inside courts, there are also plenty of what we can think of as micro causes too. So at the middle of this graphic is the 2 core problems of these high volume dockets, like really low participation by defendants who often fail to show up at all, and then also something we could call unlawful resolution, which means that cases resolve, again, often by that thing I called a default judgment, even when that default judgment is not legally warranted. All right, so the graphic then lays out all these micro causes that I think feed into these bigger problems of high volume dockets. And some of them are pretty intuitive. Cost. Lots of these defendants don't bother to engage the system because the cost of doing so in time or resources exceed any possible benefit in the case. Sometimes it's simply rational not to defend within these systems. Some of the problem is clearly informational. The legal system is Byzantine and complex, and most people, by the way, are priced out of the market for lawyers. Lawyers are too expensive for even middle-class people to afford in the United States. The few online legal help tools that are available are pretty hard to find. They're not very discoverable. They also aren't sufficiently user-friendly in many instances. Those are the intuitive causes, but I think there are two more that are a bit more complicated, but I think are absolutely central to our thinking about AI within the civil justice system, and in particular, how we might deploy AI within the civil justice system to try to widen access. First are what I call adversarialism challenges. Again, because most defendants don't show up or have to navigate the system alone, there are many, many cases where there is a meritorious defense that never gets raised in a case. Second, there are a bunch of rules out there that are designed to make up for the fact that defendants are navigating the system alone or don't show up at all. For instance, here in California, there are rules that say that a debt collection plaintiff has to attach certain things to its complaint. For instance, proving the chain of title of the debt if they're a debt buyer who's purchased a tranche of debt from a bank. They have to attach that to their complaint. They wouldn't normally need to under the civil procedure rules. That's not how civil procedure rules work when two businesses sue one another. But in California, there are these special pleading rules that are supposed to help unrepresented defendants and make it easier to serve them with low-cost legal services. But you know what? Studies have shown that plaintiffs don't comply with those rules here in California, here in Connecticut, and a couple of other states that have them. And because defendants don't know any better or haven't shown up at all, no one holds them to it. That's something that you need to know about the American legal system, which is the courts try to stay scrupulously neutral, and it's not their usual position to try to help out a party on one side of the V or the other. That's my first claim. It's about the access to justice crisis, and I've hopefully given you some sense of its scale and its scope. Here's the second claim, which is that AI, and especially generative AI, has immense access widening potential, given these conditions on the ground, and also plenty of peril, too. At the most general level, I like to think about generative AI's promise within this part of the civil justice system as a combination of what I like to call translation and mapping. Translation can for sure include translating legal documents back and forth between different foreign languages or between a foreign language and English. But more importantly, when I say translation, I mean an ability to translate back and forth between legalese and plain language. And if you want to develop tools that serve self-represented litigants, litigants without lawyers, being able to put language into plain terms is absolutely essential. That's the first place where generative AI holds massive potential. Mapping means that new generative AI tools are increasingly good at taking, say, a plain language description of a civil legal problem from a court user, and then map it to a legal ontology, to some kind of a knowledge representation of what the law requires, and then return with actionable information or advice. Right? That's the great promise of generative AI. It's clear that these tools can do it better than previous generations of AI, though, as you know, and as we'll discuss in a moment, there's a debate about how good they are at it. All right. With these advances in AI, we have seen an explosion of what you can call legal tech tools. There's basically a growing number of companies, some large, some small, and startup-ish, that provide software-based legal services of various kinds. Most serve corporations. And for instance, analyze or draft contracts for big companies. But a small but growing set of tools serve people like you or me. And they do it by performing a variety of tasks. One is document assembly, sometimes called form-filling tools. These are tools that help a party construct a document, essentially, fill out an answer in an eviction action or a debt collection action. There are now phone apps that help litigants preserve evidence, for a case. For instance, evidence of property damage or evidence of domestic violence. Some tools perform what's sometimes called wayfinding, which is just helping litigants navigate a process, understanding what the steps of a process are going to be and where they need to go in a court to do what they need to do. Some tools help to connect litigants with lawyers or other forms of legal help. So you can think of these as like legal help client matching services. And then finally, there's legal analysis. Some tools are trying to provide actual legal advice, right? Facts applied to law or law applied to facts. So we're going to see in a moment that that's complicated because the law creates a monopoly for lawyers. All right, maybe a more concrete way to think about all of this and to maybe glimpse some of generative AI's promise is to think about a different type of AI within the system. And this is something that I call Courthouse AI. And so courts have already started to incorporate AI into their operations in various ways. Some of it's really straightforward stuff you can see on the screen, like kind of document AI, back office, how do you get a filing into the court's case management system? That's real automation. It's allowing courts to do more with less. It's not exactly exciting as a access widening tool. But other things start to get more exciting. So for instance, courts have started to use AI to triage and then route cases that come in the courthouse door to different procedural pathways. You might apply different court procedures to a case based on different features, and AI has started to do that kind of triage and pathways. So also you can triage cases and try to route court users to appropriate forms of legal help. And I'll talk about that in a moment because that's one of the things we're working on with the LA Superior Court. Courts have also begun to use AI to do procedural screening. That should ring a bell. Remember I told you there are these special procedures and debt collection actions and eviction actions, and many plaintiffs ignore them. And so courts have started to develop AI-based ways to do that procedural screening to try to find those procedural problems without the need for kind of analog human eyes-on review. I'll come back to this example as well, because it's something else that we're working on currently with the LA Superior Court. Then there's all different kinds of self-help, chatbots, court portals. You talk to the most visionary court leaders around the country, and they can see a world in which a litigant could come to the court's website, could enter a plain language description of a civil legal need or an explanation of what they need done, and get back immediate actionable advice through some kind of a conversational AI tool, or get connected with tools that they might need to perform whatever task they need to perform. There's something called ODR 2.0 that's also incorporating AI. ODR 1.0 was what eBay and PayPal first developed, back in the day to help resolve small dollar e-commerce disputes, right? And in its initial guise, I call it ODR 1.0. It was basically just an asynchronous gathering place, a platform where two sides in a dispute could try to bargain their way to a settlement. Here's what's happening now. We're starting to see versions of what I call ODR 2.0. And that's still a platform and a negotiation space, but with algorithmic tools built on top of it. And so, for instance, in a divorce, the two sides could put forward preferences around particular property, and then an algorithm could come up with a settlement package that takes account of those priorities. Some see ODR 2.0 advancing to the point where we might prime disputants with other types of information, including maybe a prediction about how the case would come out if it was litigated all the way to a judgment in a court. And that allows the parties to bargain in what we call the shadow of the law, which is really important. And if you think about it, a lot of what lawyers do is help you to understand how the case might come out if it was litigated all the way to the end, because that helps you to understand your settlement incentives. All right, finally, judges have begun to use AI, and that obviously has lots of access potential in overloaded courts. Now, there are for sure concerns here. I worry a lot about legal tech leading to asymmetric distribution of legal knowledge, particularly when it comes to those legal tech providers that so often serve corporations and not individuals. For a long time, there's been a debate in law world about whether legal tech is going to democratize legal services or instead maybe further slant the litigation playing field. I worry more about slant for a very particular reason, which is that it takes more than just analytics to make really potent legal tech tools. It also takes data. And that's important because you may not know this, but most cases actually exit court dockets with a voluntary dismissal reflecting a non-public settlement by the parties, or a settlement that is actually subject to a non-disclosure agreement. What that means is that the holy grail of data for any legal tech company or provider is hard to get, non-public. As a result, it tends to be the haves of the litigation world, and in particular, the repeat players. Think of a Walmart that litigates a never-ending stream of slip and falls and employment cases. They're the only players in this system that have reliable access to case outcomes. And again, that's like the holy grail of legal tech. Even before generative AI, Walmart was already developing tools that could do a couple of things. Could predict the outcome of a case, and importantly, predict how long the case was going to take and how much it was going to cost. That's the first thing. And boy, that's power in civil litigation if you can predict those things. And also could write an answer to a complaint and then also write a first set of discovery requests. So doubling for the work that a lawyer would do. Here's the problem, of course, again, the Walmarts of the world have privileged access to the data that they need to do those sorts of things. All right, that's one concern I have about legal tech then, and AI kind of sweeping into the American civil justice system. Another is bias. Like think about ODR 2.0. If you're priming the disputants with some kind of a prediction about how their case might come out, if it's litigated all the way to a judgment in a court, you better be damn sure that there isn't bias in your underlying data, and there might well be. You can reproduce a lot of disadvantage with an ODR 2.0 system that tries to prime the disputants with information. Then there's the concern about hallucinations. And here my colleague at the law school, Dan Ho, and my former student, Neil Gua, he's not on this paper, but he's been on others, and lots of others here at Stanford have really vaulted this thinking ahead. And they've shown quite compellingly that legal tech tools hallucinate. And that's true of general purpose LLMs. And it's also true of the RAG-based proprietary legal AI tools that several major legal tech companies are marketing. That's a really bracing finding. From an access to justice perspective, their research has raised particular concerns that hallucinations might be worse as we move down the court hierarchy. What does that mean? Hallucinations get worse as we move from the Supreme Court, where it's mostly moneyed interests that are involved, down to like an eviction court. They get worse in an eviction court when we're talking about local law. They've also made the case that law might be especially challenging for AI and access to justice because of contrafactual bias, the inability of AI to handle queries with an erroneous starting point or premise. When we're talking about largely poor and less sophisticated court users, that's a big problem. That said, I believe that the hallucination research, while important, has taken up way more mind space than it should. And here's why. For starters, we've always known that legal analytics are uniquely challenging. They're a uniquely hard prediction task. Judges, when they decide cases, they use all different types of reasoning. Some of it is linguistic, like the meaning of a particular word in a statute or the Constitution. Some of it is systemic or structural, the relationship of a set of words in one part of a statute to a set of words in another part of a statute. Some of it is analogical. How much is this case like or different from a prior case? Some of it's evidentiary, right? What is the probative value of a particular piece of evidence? And then finally, there's like teleological reasoning too. Like, what is the purpose of a particular statutory provision or piece of the Constitution? We've always known that's complicated. I'm not surprised that hallucinations are quite pervasive when we're talking about really complicated case law. But here's what I think, and this is a point that hopefully I've made clear, which is that there are lots of access widening applications of AI that are not higher order legal cognitions or even legal cognitions at all. And they can all help litigants in a broken civil justice system. In other words, you can build a lot of form filling and wayfinding and legal help matching tools without worrying that a tool will say that Justice Ginsburg authored a dissent when she didn't. Claim number 3. Here's where I'm going to explain why I think Courthouse AI, not a private sector legal tech marketplace, is the best way forward for effective and trustworthy AI. So start with my view of the world, which is that when I think about courts that are buried under an avalanche of debt collections, evictions, mortgage foreclosures, and certain types of family law matters, I think they face a basic make or buy choice. And it's not the usual version of the make or buy choice that we talk about in organizational theory. So let me help you to understand what I mean by that. By make, I mean that courts can build, or maybe procure, that would be fine too, but build their own court-hosted tools. That is, tools that sit on the court's website and serve the millions of self-represented litigants who are trying to navigate the civil justice system on their own. Alternatively, and here's the buy, courts can, in effect, buy the services of a growing marketplace of legal tech companies that are using AI to serve people out in the world by making themselves, the courts, more accessible to those companies. Now, what does each of these things mean more concretely, and what's the catch? For the moment, make largely means courts all around the country that are quickly digitizing a whole suite of self-help tools that they started to build in the 1990s very much in an analog era to try to deal with the growing numbers of self-represented or pro se litigants. And so back then they had a lot of court navigators. They started to use court forms. They had in-person self-help clinics. What's going on right now is we're digitizing all of those. Courts are starting to explore chatbots. That's Gina, the traffic court chatbot in the LA Superior Court. Courts have started to bring in ODR platforms, and courts have started to host their own form filling or document assembly tools. Remember, those are the tools that allow someone to construct quickly, essentially by filling in blanks, an answer to an eviction lawsuit. Make has some problems. The obvious one you've probably already guessed, which is that courts by and large lack technical capacity. And that's a problem of public sector AI more generally, but it's a big one. And I don't want to give short shrift to that. What does buy look like? Buy means doing everything courts can to try to foster a robust legal tech ecosystem by making it easier for those legal tech providers out in the world to connect with courts when they're serving clients or serving customers. It means building APIs. It means making it easier to electronically file or e-file documents into the court. And you'd be surprised how far behind many courts are on even things like basic e-filing. That all sounds good if we could foster that really robust marketplace of legal tech providers out in the world, but there are some problems, and some really significant ones. And in fact, my view is that the buy side problems, the problems that afflict the buy side of make or buy here, are actually much more significant than the problems on the make side of things. First are basic regulatory constraints. Nearly every state has a rule that says only lawyers can practice law. That's UPL, or unauthorized practice of law. In fact, it's a crime to practice law without a law license. And also there are rules that say that only lawyers can own and therefore capitalize law firms. That's Rule 5.4 of the Model Rules of Professional Conduct. The stated reason for these rules is quality control. We want to make sure that legal services providers are high quality. But in reality, these rules also just prop up a simple protectionist lawyer's monopoly. And they've also cut off law from most of the sources of innovation that have remade much of the rest of the modern economy. That said, there's some reasons for optimism here. There's a movement afoot among states, especially state Supreme Courts, to relax these rules, to relax the UPL rules, and to relax Rule 5.4 to make more room, to make more space for alternative types of legal services providers. In some cases, they're what I would refer to as non-lawyer humans. So think of like a nurse practitioner type figure for law with specialized expertise in eviction or debt. But in some cases, it's non-lawyer, non-humans, meaning software-based provision of legal services. I've done a lot of work in this area. I've worked with a half dozen state Supreme Courts now to think about how to responsibly relax those rules. I've also done some of the first real empirical research to understand in the two states that did it first, Utah and Arizona, what types of innovation, what types of software-based legal services do we actually get when we try to relax these rules. The problem is it's for sure a movement, but it's not moving very fast. I was on what you could think of as like a blue ribbon commission here in California a couple years ago, and we were tasked with making a recommendation to the state bar, to the California legislature, and to the California Supreme Court about how California might consider responsibly relaxing these rules to make more room for other types of legal services provision. And we worked for about a year and a half, and then we got shut down unceremoniously by the judiciary chairs here in California because the plaintiffs' lawyers complained to them, and so they shut us down by depriving us of any further funding and any ability to operate. I then wrote an intemperate piece in Slate expressing my displeasure with a pretty bracing title. So that's only one problem on the buy side of things. Here's a second. When you look out across the roughly 14,000 local court jurisdictions in the United States, that's how many there are, 14,000. They are a checkerboard of technology systems and data infrastructures. As a technology matter, many of them are their own fiefdoms, and they're very unstandardized. And that's a real problem. It deprives legal tech providers in particular of the scale that they might need to serve a population that by definition has limited ability to pay, and that may also, unlike like a TurboTax customer, may only need services once. And so it's a basic scale problem. And so this is another project I've worked on quite a bit. I founded a project with Margaret Hagan here at the Legal Design Lab, and also Mark Chandler, who had just stepped down as the general counsel of Cisco, so one of the world's largest technology companies. We created something called the Filing Fairness Project, and we've been working with states and state courts to try to standardize their technology systems and their data infrastructures to deliver that scale that legal tech providers might need to have sustainable business models for serving litigants in this area. So, we're trying hard, but it just might be the case that the market economics on the buy side of things are just too challenging. I have concluded that we shouldn't expect a robust legal tech marketplace serving poor people anytime soon. Part of that's regulatory, as I noted, but I think more importantly, it's just the uniquely challenging market economics of serving poor people who by definition have limited ability to pay. All right, so far then, when we're thinking make buy, make's looking pretty good, right? But there's a final consideration that I think makes it look even better. And I call it the sea of junk. The coming of LLMs to our world and the coming of ChatGPT and Bard and Gemini and all the rest has made something that looks an awful lot like legal information and even advice available to Americans, and it's basically free. Some of that advice is quite good. You just go on ChatGPT and ask a legal question, you will get an answer, and sometimes it's right. But some of that advice, and maybe even a lot of that advice, is quite bad. That's the sea of junk. And it's a huge concern as we think about how AI is going to transform the civil justice system. I worry about a couple of things. I worry that regulators or state legislatures may decide to simply tell OpenAI it can't do legal anymore. That's entirely possible in my mind, given what I know about the politics of this area. And a big part of it would be a concern about the sea of junk. But I think there's a further critically important implication. I already said it, which is that I think the sea of junk concern maybe should push us towards make rather than buy. I actually think that there's an argument that courts may be the one remaining authoritative and trustworthy source of legal information. And so if what we want is effective and trustworthy AI, it's possible that Courthouse AI, as I've described it, is the way to do it, not to hope that we can build a robust legal tech sector out in the world that's going to serve poor people. Fourth claim. Before I get there, we can review the bidding a little bit. We've got a really deep and wide access to justice crisis. Generative AI has massive access widening potential and also plenty of peril. And given various political and economic challenges, courts may be our best hope for incorporating AI in trustworthy ways into the American civil justice system. Now, my fourth claim, which is frankly, at least in part, a report from the field and an invitation to members of the high community to get involved. But in any event, here's the claim, which is there's a new partnership between Stanford and the LA Superior Court, the largest trial court in the country. And I think it provides a truly unprecedented opportunity to design, implement, and evaluate AI in the wild in legal. About a year ago now, my research team at the law school and also Margaret Hagan's legal design lab announced a major research collaboration with the LA Superior Court. And we've spent the last year or so with full access to their data and systems and have started to work up a set of paths forward for the court. Some of the interventions we're working on with the court are purely analog. There's no AI anywhere near them. I won't tell you about those. But some focus on building, implementing, and then rigorously testing new courthouse AI tools, and I will tell you about those. So for starters, I can tell you that this partnership is absolutely ideal on numerous fronts. I've already noted it, but as the largest trial court in the country, you can imagine that there's actually an enormous volume of cases. So for instance, these are monthly filings in the eviction context. There are about 50,000 eviction cases per year. And the court has more than 10 years of digitized court records going back. So there's an enormous amount of training data here if what you want to do is try to develop forms of courthouse AI that can widen access to justice. Second, the court has engaged members of the Stanford research team as research contractors, which gives us unparalleled access to the data so we can do real work in a court system. I think that's the first time there's ever been a research collaboration that looks anything like that. Third, the court actively wants to build out the evidence base on access to justice, and it supports rigorous research methods. And that means things like randomization, which, as many of you know, is sort of the coin of the realm in social science and data science as well. If we want to draw real inferences about the impact of a tool, you need to be able to randomize. Fourth, the court wants to become a leader in AI. In fact, the court talks about wanting to build that one-stop shop conversational AI presence that I described earlier, where a court user can come to the website, enter a plain language description of a civil legal problem or a task that they need to perform, and get back actionable information or advice, and maybe even a connection to a tool, be that a document assembly tool or what have you, that they're going to need to perform that task. So at the moment, we've begun to pilot 2 different AI-based tools with the court. And you can think of one as internal and court-facing, and the other as external and litigant-facing. Here's the internal court-facing tool, and I already mentioned it. It's a default prove-up tool. I mentioned previously that many and even most cases in these high-volume dockets end in default judgment because the defendant fails to show up. And sometimes those default judgments are not legally warranted, but there's no one to contest the case. And so some courts, including LA, have started to check the legality of the default judgments before they enter them to make up for the fact that the defendant isn't going to contest the default judgment. Courts have started calling this a default prove-up process. That's a really big deal if you know anything about the American legal system, because it means moving away from the position that American courts have long occupied, in which they try to remain scrupulously neutral as between the 2 sides of the V, the 2 sides in a case. But LA's doing it. In fact, they've been doing it for years. But the way the court has been doing it is purely analog and human. In fact, a single court staff member, call him Kevin, does them to the tune of thousands of cases per year. And it takes Kevin roughly 20 minutes per case to do the prove-up process. Here's maybe the best part in all of this, maybe for Kevin, but also for us. He's about to retire. And so there's this incredible opportunity to think about, are there ways to automate this process? And are there ways to build a tool that could do the prove-up process both within LA, but could then also spread to other jurisdictions that maybe can't afford a Kevin, but would benefit from a default prove-up process? We believe that the current rejection rate in the analog human version of the default prove-up process is about 1%. So we're finding problems in 1% of cases currently. But our back of the envelope work so far, and from really working closely with the court staff that do this, we think the actual rejection rate could and should be somewhere closer to 10%. That's an order of magnitude improvement, many order of magnitude improvement in finding cases where default judgment would otherwise enter that's not legally warranted. This is a hugely impactful tool, potentially. So we've spent a good bit of time observing that human analog process to understand what would need to be automated. On the eviction side, a prove-up tool would ideally flag multiple types of problems. Perhaps the landlord didn't serve proper notice, either by jumping the gun. They have to wait a period of time between serving notice and actually filing an eviction complaint. Or perhaps they simply served the wrong type of notice. Perhaps the damages weren't calculated correctly. For instance, the rental contract may have specified damages or attorney's fees, or perhaps holdover damages, where post-eviction someone remains in the property, entitling the landlord to collect damages. Perhaps those weren't calculated properly. Perhaps the eviction action was improper because it was brought when the rent arrearage, the total amount of rent due, was below a threshold set by law. In many municipalities around LA, you can't sue for eviction until the amount of rent arrearage is above a certain amount. On the debt collection side, there are other things to flag. As already noted by law, there are a number of items that a plaintiff is supposed to include in their complaint, is supposed to attach to their complaint. So for instance, that proof of the chain of title of the debt in the case of a debt buyer. There's also the statute of limitations. A lot of debt buyers bring forward cases where the statute of limitations is already run. That's the rule that says you have to file within a certain number of years. These are the sorts of things that we think we can automate and build a better prove-up process that doesn't rely on analog human eyes-on processes. You're maybe already seeing some of the technical challenges. I am sitting over here in the CS department after all. So, first, these tools are going to depend on multiple types of reasoning. So on the one hand, numerical data, such as dates, but also, or numerical reasoning, such as dates, but also what you can think of as like entity correspondence issues. So tracking an entity through a sequence. And so this is very much a multi-step reasoning problem. The second problem you face when you try to automate one of these processes is that the information is often located in multiple different documents. And so there are challenges from cross-correspondence among documents. You can think of this as a form of multi-hop reasoning, which I think brings technical challenges if you want to automate. There are plenty of HCI, right, human-computer interaction challenges too. The user interface needs to be really well designed if it's going to aid court staff as they do these prove-up processes. In fact, I think the prove-up tool raises all the usual questions in HCI about what happens at the human-machine interface when you're handing off a machine output to a human who's then going to make some kind of an ultimate decision. How do we hedge against over-reliance or under-reliance on the tool? All those questions around that this is a socio-technical system that's going to blend human and machine judgment. And so that's stuff we're going to have to work on and think about and generate research around. Here's one of many reasons I'm excited about this tool. We basically have very few rigorous studies that look at use of legal AI tools that don't come from companies selling those tools. And while we're doing an increasing amount of work in artificial settings, it's been really hard to do the translational work that's necessary to show that these tools work or don't inside legal institutions, whether that's law firms or prosecutors' offices or courts. And so I think this part of the project is going to be a big leap forward on that ground alone. Now to the other tool, the external litigant-facing one. We're calling this a triage referral tool. In many of our conversations and focus groups with court staff, we've learned that those staff are inundated with requests for referrals to legal services from self-represented litigants who are desperate for help. It's one of their principal pain points, say court staff. But the court doesn't currently have any centralized process or guidance for its staff. And the staff don't necessarily even know what services are available or which ones work. And part of the problem is that the legal services marketplace is changing really fast. There are all these new companies that I've already shown you. And so the ecosystem is really complex. There are all sorts of places one could go to try to get help if they're facing an eviction complaint. And that ranges from like full service, like a full lawyer at a legal aid organization over on the right-hand side, to like DIY digital AI-based services on the left-hand side. One way I like to think about this is I think over time, we're going to see a pretty pronounced shift from the right-hand side of that to the left-hand side of that. I think as generative AI continues to flow into the system, as we see the regulatory relaxations that I talked about, you're going to see more and more DIY digital AI-based legal services delivery models within these systems. So here's what we're doing. We're building a tool that's designed to rationalize the allocation of legal services within this ecosystem. And the idea is that there would be a place on the website where a court user could come, and they would be asked some questions. And those questions would elicit a mix of objective information and also subjective preferences from the court user. On the objective side of things, you could ask them their address, because some legal aid organizations only serve clients in a particular part of the city. Could also ask them whether they're receiving particular types of public services, because that's a really good proxy for their eligibility for various low-income legal services that might be available. That's the objective stuff. The subjective preferences that we could ask about and that we could elicit would be, what do you want? Do you need a full human lawyer here? Or would you be okay with a DIY digital solution of some kind? Or maybe something in between? The tool will take this information, ideally map it to a pending case in the court's case management system, and then come back with a curated list of legal help options, including quite granular ones, including you could say there is a group workshop that helps you to fill out an answer in an eviction case that's tomorrow or the next day near your residence, okay, at a community center near you. It could be that granular in terms of its ability to make available appropriate forms of legal help for people. Ultimately, as I've noted, the court wants to build out a kind of one-stop shop conversational AI presence on its website. We see this as the first step, but we want to try to help the court to get there, to get to that fuller, one-stop shop type approach. As we move toward that goal, there will be many challenges, many rich research questions. One of the most substantial is that legal conversations, maybe a little like medical conversations, are inherently more complex than static bar examination questions. And that's where we've done so much of our work so far on ChatGPT and its legal capacities. Instead, real-world legal conversations require iterative information exchange, clarification of problems, continuous diagnostic reasoning. That's where it feels a little bit like medicine. If you're around law, you know that legal conversations can be quite unique. I'm a lawyer, I'm a litigator, so I have them all the time, but I don't know if maybe you've had the misfortune of having lots of legal conversations with people like me, but generally a person asks a question, and then the lawyer responds with 3 questions. And there's the further problem that the person may not even know what questions to ask. And so as a result, this is just different from the usual chatbot paradigm as it exists, I think, out in the world of commerce, for instance. This relates to a concern that I've already noted, which is that legal AI might be uniquely vulnerable to what is variously termed contrafactual bias, falsehood mimicry, or sycophancy, where a system generates an output that fits the user's false assumption or erroneous premise instead of offering clarifying questions or factual correction. And so that's one of the huge challenges in legal AI. And if the LA court is going to build a fully conversational AI interface, it's going to have to struggle with that and grapple with that. All right, I'm going to leave off there, but let me offer just a closing set of thoughts about public sector AI and the role that Stanford can and should be playing in a wider public interest technology movement. In some ways, that's what I've really been talking about here today. So in a recent HI seminar right here, Russell Wald said that for AI to be developed responsibly and in the public interest, academia must continue to play a central role. I know my colleague, Stanford Law colleague Dan Ho, has been making similar arguments here at HI for years. I couldn't agree more. And I actually think that this project exemplifies what that role and what Stanford's role could look like. In fact, going back to what I said at the start, I think Courthouse AI is one of the most compelling, but also underdeveloped and understudied parts of public sector AI. So here's a plea, if you're here today, or if you're watching this, on Zoom or watching this later on YouTube, if you're interested in what I've said, if you'd like to become involved, we're hiring. We're looking for ways to build out our team further. We already have some great data scientists, but we need more. And whether you're a faculty member, a postdoc, a grad student, an undergrad, someone in industry looking to make a change and work on AI for good, I will say this, which is please contact me if you want to get involved. All right, thank you, everyone.
Hi, my name is Felipe. Pleased to meet you. Well, I got many questions for you, but probably at the same time, there are going to be some concerns. I'm also a litigator, but I'm a Mexican litigator. So I just recently came here to the US to pass the bar examination. But I came here in the age of AI. And I was one of the first litigants in Mexico to use ChatGPT. Nobody knew how to use it back in 2022 when it came, the first release. Then I created my own academy of cybersecurity, and then I became, I'm a fan of the AI because everything that comes from here, I take it back to Mexico. Right now, we're passing through a very serious tension in Mexico that the whole judiciary is getting rid of. And now this idea of having robots as judges has come to the place where we might actually come to it because, as you know, our judiciary is going to be deleted just out of the nowhere in this June. But at the same time, yesterday we saw with Elon Musk. Yesterday took over the White House with technologists. So the idea that you were saying that experts on AI, the UPL word, unpracticed, unlawful practice, it's a very soft word, but at the same time, it has already taken here in the US. Yesterday, somebody that is not an attorney took decisions to wipe out most of our administrative law options. I mean, he doesn't know anything about administrative law, or at least I think, but that's the thing. What do you think about yesterday and what you were talking about, the rule of law and AI?
Okay. Boy, I'm trying so hard right now not to think too much about political events. And, I'm actually, the class I'm currently teaching over at the law school is called administrative law. And it's the law that governs government agencies and the president. And so, for instance, by just coincidence, I taught a class on executive orders on the second day of the Trump administration. So literally during my 90-minute class, the Trump administration issued 7 executive orders. So I'm trying not to think too much about it. I'm already involved with my students. And so I'm not even sure what you're talking about as to yesterday, like something swept away a bunch of technology. Would it be possible just to refresh my recollection on that?
Well, the thing here is that Elon Musk has made an audit on all the on USAID and all the money that has overflown. But now, from the White House, he has stated that most of the things have to go away. But that's an administrative decision that has to go under the rule of law.
Yeah. Okay. Got it. All right. So this is a question about general threats to rule of law. Let me deflect the question a little bit and just say that everything I just told you about today is happening at the state court level. And that might be one of the beauties of American federalism, right? This access to justice crisis is largely in state courts. By the way, federal courts are only 3% of cases in the United States. State courts are 97% of cases. All of the action and all of the cases that I just told you about are all in the state courts. So whatever is happening in Washington right now, it's clearly going to have an effect down the federalism chain, but it's not going to have as great an effect as it is on the federal government. And so that's why I'm really proud to be working with a court in LA to try to find better ways to serve court users who are currently navigating the system on their own. Let me say one more thing about politics, and this is pure deflection again. I'm not answering your question at all, but I think it's useful to note. I told you during my talk about this movement to relax the rules that say that only lawyers can practice law and only lawyers can own law firms. And I told you about, really quickly in passing, 2 states that have done it. What were those 2 states? Utah and Arizona. Those are the 2 states that have actually relaxed these rules, and where I did that empirical study where I said, okay, what types of legal innovation actually present or actually result when you do that? Why Utah and Arizona? It's weird, right? These aren't progressive states. And how come the effort I was involved in, that Blue Ribbon Commission here in California, got unceremoniously shut down? I thought we were a progressive state here in California. The answer is the politics of access to justice is really interesting and purple. And here's why. In states like Texas, there's actually been an enormous amount of activity to try to think about how to relax those rules, to make more room for human service providers, but also software-based service providers. It's actually been a surprising amount of activity in Texas. Why? The folks on the left want to improve access to justice, and so they're all about deregulating the legal profession and to make more space for service providers. And the folks on the right just love to deregulate any industry. And so you get this really interesting, sort of strange bedfellows as a political matter. And so I think we're going to see this happen, and it is going to create more space for software and AI-based legal services. But interestingly, it's not going to happen probably in California or Massachusetts. It's going to happen in places like Texas first. And that's what I'm waiting to see. I'm waiting to see where, a really big legal market like Texas with a bunch of really big cities in it. I'm waiting for that big state to make this move. And I think it's going to happen, and that could have things pick up speed. All right. That was a twofold deflection, but maybe it kind of takes your question, which was about politics and expertise, and brings it around a little bit more to my concern, which is what's happening in state courts in these, low value but high consequence cases. All right, thank you.
Hi, I'm Helen Nissenbaum, visiting here from Cornell.
Mhm.
I love the way you set up the make versus buy.
Uh-huh.
And I agree with you in thinking that the make alternative has virtue over the buy.
Mhm.
But I did disagree with one of your arguments.
Okay.
And that is the idea of lawyer monopoly. And I've done work, for example, on questions about educational software and is that as good as teachers or not? This is even way back before we had generative AI and so on. But I think that one thing I would like to see the argument pick up is what more there is that the lawyer provides than information. And that is a commitment to professional ethics. And the same with teachers. So teachers are not only, we're not going to say, is it true? How well do the kids? But what when there's a problem? Who's going to be accountable for that? The lawyer's commitment to confidentiality and to serve as an agent on behalf of the plaintiffs. What happens to that when you transfer over to the product that you've bought, the app or whatever it is, and behind that is a tech company, and I'm just giving a dark story, that's gathering all the information and has no commitment to confidentiality or to serving as plaintiff agent. And that's the part that I think has to be part of your story as well.
Great. So I tend to agree. And whenever I talk about relaxing the rules to make more room for other types of legal services providers, I always, you might have noticed, use the word responsibly. I think the devil is in the details about how we do it. So the conventional explanation for why we regulate law the way we do and why we say that only lawyers can practice law is that we think of law as, this is an economist term, but we think of law as a credence good. And the definition of a credence good is that the consumer of the good has trouble gauging or judging its quality. And we don't think that markets work very well with credence goods. And so what do we have? We have bar exams. We have, people have to come and learn from me for 3 years at Stanford Law School before they can go practice law. And so we put in all these barriers to entry in the name of quality. Okay? And then you need UPL rules in order to say that someone who hasn't taken 3 years of law from me can't practice law. Rule 5.4, which says that only lawyers can own law firms, is to try to take the profit motive out of law. And of course, that sounds ridiculous at one level. Like law firms are there to make a profit. Like white shoe law firm partners are making between $5 and $10 million a year right now in major legal markets. They're doing it for money. But the point is that we don't want profit to infect a lawyer's judgment once they're in the case. And so the idea is a lawyer has to decide at the front end of a representation whether they want to take the case and whether they can afford to do it and still keep the lights on in their law firm. But once they've taken the case, they're supposed to litigate without concern as to like the profit, without a profit motive, or at least without a personal profit motive in the case. My point is only that like there's a perfectly good conventional explanation for why we have these rules. But, policy is all about trade-offs. And so, when you look at the scope and the scale of the access to justice crisis, and I spent a good amount of time in part one of my presentation talking about it, there are also real costs. There are also real costs to propping up a lawyer's monopoly and making it so that most people are priced out of the market for legal services and don't have any other place to turn other than lawyers because no one else is allowed to full-on practice law. And so it's a trade-off. And so that's what's going on right now in state Supreme Courts. The basic argument is, yeah, there are good reasons to regulate this, credence good, need to maintain quality, have all sorts of concerns about profit motives in law, and yet there are also all these collateral costs of that regulation, which is we have a dysfunctional legal services marketplace that doesn't serve people very well. And when I say doesn't serve people, I mean millions of people. Remember, 75% of 20 million filed civil cases per year, at least one side lacks a lawyer. That is a dysfunctional market. And I think that's what's starting to move state Supreme Courts to rethink how we're going to regulate legal services, again, including software and AI-based services. So thank you for the question.
Hey, good afternoon, Professor Engstrom. My name is Aluna. I'm also a visiting scholar and came from HEC Paris and also the High Paris Center on Artificial Intelligence. So I myself happen to realize that some of my work is at the intersection of regulation, AI, and digital rights. But maybe we can talk about that offline. I have one question about one of your recommendations regarding the use of ChatGPT. You said it's possible that the states can say that we don't let our large language models to do legal. But I think, distributing information, knowledge, right? So we cannot just rule out all the legal knowledge. I'm sure a lot of Stanford Law students, they use ChatGPT to help them to gain knowledge.
I suspect.
So I think what Helen just said actually speaks to me about what we need when we need lawyers, not only we need information. So for example, there are certain filings we kind of need lawyers to do that, right? We cannot do that on our own. And also, so let's say if my tax attorney give me advice and help me to do something, we can hold them accountable, not only me, but them accountable for certain actions, right? So it's accountability and authority that we need. I think as long as the current framework protect that about lawyers, right? So we can still allow the AI company to distribute some of the knowledge, but and people know that maybe the legal tech owned by lawyers, right? They can train, like they can have someone like you to help them, so they have higher quality advice, and then people know that your ChatGPT gave relatively low level advice. So what do you think about that?
Great. So I completely agree that ideally legal tech companies, if what we want is, where we're gonna put our chips is buy, right? And we're gonna try to build a robust legal tech ecosystem out there in the world to serve people, then I agree that ideally those entities would have lawyers in them. What you don't want is like lawyerless tech companies without any understanding of what day-to-day litigation looks like or where the potential ethical pitfalls and challenges are, just building kind of what they see as new, moving fast and breaking things and trying to build new ways to serve people. That seems wrong to me. And that's why I always say responsibly when I talk about relaxing the rules. So one of the things that I've worked with state Supreme Courts a bunch on is how do we relax those rules in ways that create incentives for entities to maintain lawyers in leadership roles in these companies. And there are a bunch of different ways we could talk offline about that. And so that strikes me as like lawyer-led regulatory reform. So if we're going to reform the system, if we're going to liberalize the rules that say only lawyers can practice law, maybe we should try to figure out ways to do it that keep lawyers in an important position within these entities and at least helping to pilot these entities. That's the first thing I'll say. You also talked about accountability, and that's again, like, I said responsibly. I think we need to think hard if we're gonna liberalize legal services. We need to think hard and ensure that there still is accountability. Right now, there is at least some accountability. There's a bar disciplinary apparatus that if you're a lawyer and you color outside the lines in terms of legal ethics, like you can be, you can have your license suspended. You can, have all sorts of various, sanctions imposed against you. So there is accountability now. The question is, what kinds of accountability could we build in a world in which we're also providing lots of legal services via software? And there, I've made arguments in print. I have a book chapter coming out in the book soon that says, hey, that bar disciplinary apparatus, that's all state level. It's all state bar associations that do it. They're, that's a self-regulating profession. They're responsible for their own discipline of their own professionals. It's all at the state level. For one-to-one legal services, why don't we keep it at the state level? I'm not sure that system has served us that well. There are all sorts of problems with it, but try to wrest it from the state bar associations might not be worth the fight. But what about one-to-many models? That's a way of thinking about what legal tech companies do right now. They're not one-to-one models, they're one-to-many models of legal services delivery, right? It's coming up with automated ways to serve people at scale. What about those? How should we regulate those? Probably not those state bar apparatuses at the state level. Like, if you think about those software companies that are serving people in one-to-many ways, it's a consumer protection problem. And we have agencies, and we have laws that cover consumer protection. So here's the argument I made in print recently. I said, why don't we keep one-to-one legal services within the state bar associations and within the state bar disciplinary apparatus? But for other software-based legal services, one-to-many, you can imagine an FTC or a purpose-built agency or state attorneys general. These are all like traditional enforcers of consumer protection laws. Why shouldn't they be the ones that are tasked with creating at least some accountability for these new models where there's at least some concern about consumer harm?